Welcome to this week's PTO Hour. My name is Deborah Lashley Johnson. I'm the Acting Director for the IP Attaché Program in the Office of Policy and International Affairs, and I'll be moderating today's panel on the IP Attaché Program. This week, we have 13 attachés and specialists back at the USPTO for a series of meetings with USPTO leads, industry, and the interagency. Thanks to OCCO for the opportunity for us to be a part of PTO Hour. I'm joined by 3 attachés today. We have Mike Mangelson, who's the IP attaché working at the US Embassy in Beijing, Rachel Bay, who's the IP attaché for Europe at the US Mission for the EU in Brussels, and Cairo Jennings, who's the IP attaché for Mercosur at the US Consulate in Rio, Brazil. Before we hear about the experiences of our panelists as IP attachés posted in their respective embassy and consulates, I did want to provide an overview of the program first. The USPTO posts IP attachés around the world to improve intellectual property systems internationally. An IP attaché is a US diplomat assigned to a US embassy or consulate abroad, representing the USPTO as an expert on IP matters. The IP Attaché program was created in 2006 and arose from the PTO's recognition of the increasing challenges U.S. right holders face in the protection and enforcement of their intellectual property worldwide. The lack of predictable and transparent and strong protection of IP for U.S. right holders remains a problem in many countries around the world. The need for IP protection and enforcement around the world is critical for U.S. industries. Intensive industries, IP industries, form an integral part of the American economy, creating more than 63 million jobs and adding $7.8 trillion in value to the GDP. So in response to this critical issue of worldwide IP protection and enforcement, the IP Attaché program was created. We have 14 attachés in 11 countries, which include Beijing, Guangzhou, Shanghai, Rio de Janeiro, Lima, Peru, Mexico City, New Delhi, India, Geneva, Switzerland, Bangkok, Thailand, Abu Dhabi in UAE, Johannesburg, South Africa, Kyiv in Ukraine, and Brussels in Belgium. Aside from the 2 Geneva-based attachés who handle multilateral issues and Mike, who covers the national level IP issues in Beijing, the 11 other IP attachés have regional coverage in their portfolios. The work of IP attachés advances the USPTO's international agenda to help U.S. right holders obtain fairness and transparency in foreign IP systems, to have foreign governments respect IP for the benefit of the U.S. business community, and to help enforce against IP threats. IP attachés provide assistance to U.S. stakeholders such as businesses, legal representatives, right holders, with issues in navigating the IP systems in foreign markets, such as providing information on a country's IP laws or points of contact with key enforcement agencies to address enforcement hurdles. They're resolving issues related to obtaining IP rights in foreign jurisdictions, such as advocating with relevant foreign government agencies for changes in policies, laws, and regulations related to IP. And they're helping to address systemic IP enforcement challenges abroad, namely by providing IP enforcement programming to host government officials such as judges, prosecutors, customs officials, police officers, and policymakers. One of the biggest enforcement issues that attachés address in their host countries and regions, it's the issue of piracy and counterfeiting, which is detrimental to all U.S. industry stakeholders. This is from personal consumer products to digital content to even autos. When a U.S. business is having difficulties with counterfeiting and piracy and is unable to enforce its IP rights in that country, our attachés help to educate host government officials by sharing best practices to stem piracy and counterfeiting. IP attachés also provide targeted programming for relevant foreign government ministries on a range of IP issues, such as patent and trademark administration and substantive legal protection issues. The attachés also conduct public awareness programs in country. They're engaging with professors, legal practitioners, local politicians, business people, and students on the importance of strong IP protection and enforcement. Developing those synergies with local IP stakeholders help to advance our position in country. Lastly, IP attachés present, explain, and advance U.S. government positions in government-to-government meetings, including bilateral, regional, and in the case of our 2 Geneva attachés, in multilateral forums. So now that you have some background in terms of the program, let's hear from the IP attachés on the ground. First, I'll start off with Mike. I would love to hear about yourself, including your areas of responsibility.
Great. Thank you, Debbie. It's a pleasure to be with you today. So I'm Mike Mangelson, and I'm the IP counselor in China. I'm posted at the embassy in Beijing. I serve as the Chief Intellectual Property Officer for the U.S. in China. And in this role, I work a lot with rights holders and companies in helping them to protect and enforce their IP in China. A little bit of background, I came to PTO about 10 years ago as the IP attaché in Shanghai. I was there for 5 years, came back to headquarters here in Alexandria, and was here for the pandemic years. And then about 2.5 years ago, I went back out to China in my role there in Beijing. I was not with PTO prior to my experience here as an IP attaché. I was in the private sector, started on the West Coast with a law firm there, and then was, because of my background, I speak Mandarin Chinese. It was one of my majors in college. I have many years of experience in China. The firm sent me to the Greater China region, where I spent the first part of my career. So I was in the private practice for about 20 years, focusing mostly on trademark and brand protection. And now I'm in China, where I have to really face all of the issues that relate to the companies and what they're facing in China. Some of the responsibilities that we have as IP attachés, at least in China, of course, it all starts with working with the rights holders and understanding their issues and the concerns that they have in China. We do a lot of work with new-to-market companies that are coming to China for their first time. I'll say that when I was in Shanghai, we did more of that. Probably a majority of the work that I did was working with companies that were coming to China, looking to do business there, and wanted to have help in helping to develop strategies for best protecting and enforcing their IP. That's changed over time, over the last 5 years, I think, since the pandemic. We don't have as many small and medium-sized enterprises that are coming to China. So a lot of our work now is focused on the larger companies that have maybe are in China for China and are facing difficult issues in terms of protecting and enforcing their rights there. So I'll leave it at that.
Thank you, Mike. Yeah. Thank you. So now I'll move on to Rachel. Tell us about yourself and your areas of responsibility.
Thanks very much, Debbie. And I, too, am very delighted to be here with all of you today. I cover Europe, and that includes the European Union, the countries of the European Free Trade Area, and then the United Kingdom. Just a little bit about myself. I'm of Korean origin. I grew up in California. I became a lawyer, became an intellectual property negotiator, worked in an international organization in Paris, and now I'm here in Brussels, Belgium, as the intellectual property attaché, which I think is a natural transition based on my background. But seriously, I am grateful and I feel privileged to represent the United States in Europe. But probably mostly, I am delighted to be in my position representing the U.S. Patent and Trademark Office and amplifying the good work of my colleagues and the organization. In terms of my responsibilities, I think Debbie already touched on it, but maybe just to dive a little bit deeper into the details. So much of my work involves following legislative and policy developments in Europe. And this means meeting regularly with my counterparts in the European Union Commission and in all of the member states as well, and also information gathering, so we can send it back to my colleagues in Washington. We also organize programming to share our best practices in the United States with our counterparts in Europe. This helps to strengthen the intellectual property regime of the countries in the region, which is only good for, well, it's good for everybody, good for companies, good for intellectual property stakeholders. So, of course, it's helpful to the U.S. economy generally. And then we also help individual companies help develop their intellectual property strategy in the region. I think many American businesses know the U.S. system for intellectual property, but are less familiar with international or foreign intellectual property regimes. And so we help them by talking through how best to protect their intellectual property in Europe. And then in some cases, businesses have problems with their intellectual property in my region. And so we help talk them through the problem, and then usually we'll refer them to or suggest that they reach out to a law firm or a local lawyer. But we kind of help them think through how they might address their issue. Maybe with that, I'll stop.
Great, thanks for that, Rachel. And now we'll move on to Cairo. Cairo, tell us about yourself and your areas of responsibility in the Mercosur region.
Sure thing. Thanks, Debbie. Great to be here talking to you from USPTO headquarters. My name's Cairo Jennings over Mercosur. If you're not familiar with that, that includes Brazil, Argentina, Uruguay, Paraguay, and Venezuela. So by way of background, I was in private practice for about 9 years, doing IP law from Texas. Had a lot of clients around the country and helping them engage in business around the world. After that, I joined the State Department as a Foreign Service Officer. I was an Econ Code Reporting Officer and had a lot of fun with that for about 5.5 years. Then I transitioned to the Department of Commerce, where I was a trade attorney for about 5.5 years, doing some policy work, and just recently became an IP attaché, and I've been doing it for just over a year. Primary responsibilities, I mean, it's what you've just heard. I think we are a very stakeholder-driven organization. And when I look back over the past year, I saw the statistics last night. My office has had about 320 meetings with individual stakeholders over the past year. So I think we get a pretty good sense of what's happening as U.S. companies engage in that region. And it really falls into 3 categories. So the first, you've heard it, is market entry. Folks that are not currently doing business in Mercosur, but they want to do business. And that's a lot of fun because it's often SMEs, companies that don't necessarily have a huge in-house team or a lot of experience in exporting, and we can really engage with them and give them pointers as they strategize their market entry, common pitfalls, things to watch out for. If you're very familiar with the filing requirements in America, they can be totally different in other countries. The subject matter, the filing requirements, the enforceability, these are all new to a lot of exporters, and we get to be sort of the first counsel they receive on this, putting them in touch with their legal counsel, of course. The next category, I would say, is really folks that are already in the market, they're established, and they run into problems. So this is, a competitor has stolen their technology, a business deal has gone bad, maybe a distributor agreement blew up, or a co-development agreement wasn't quite clear on who owns what, things like that. It could also be specific actions of a government or an agency that they could use a little bit of advocacy to figure out next steps. So we can step into that. And then the third category, I would say, is sort of more the macro IP environment. Stakeholders that really want to influence that. And so you're talking about usually very large US companies with huge portfolios, or you're talking about industry associations that represent many stakeholders, and they want us to engage on particular policy issues in the country. And so we'll work with interlocutors in the government. We'll try to address those issues. So that's kind of my areas of responsibility.
Great. Well, thanks for those introductions. Let's try to get into some details now. So would love to know, what are the top 2 to 3 issues that you work on in your respective regions? Mike, you want to go first?
Sure. I think probably the top of the list is in the area of brand protection. I think this is probably in terms of the most pervasive problems that our companies face in China. And it starts with protecting the trademark and registering trademarks. China is the first to file jurisdiction, and it's led to some issues with bad faith trademark filings, with squatters who are filing for the brands of our rights holders first in China, which could cause difficulties in acquiring trademark rights in China, which also makes it difficult then to enforce against infringement and the counterfeiting that is pretty rampant in China. The counterfeiting, I think, over many years that I've been in China, I've on and off for 40 years, that's probably been top of list in terms of the issues that our companies face there. And I think China's done a good job in coming up with ways to enforce against the counterfeiting issues, although we have the rights holders are very adept at coming up with new ways and technologies to avoid detection and enforcement. So we always have to be on top of the game in that area. I think the number two area would be safeguarding technology, and that is kind of come to the forefront of our relationship with China right now, and that is protecting, against trade secret theft, having enforceable patents. We have issues with an invalidation of patents that is focused on certain key critical technology spaces. I think in the trade secret space also, that is an area that we're focusing on heavily now, and particularly as it relates to strengthening trade secret protections in administrative licensing. You may have seen recently with the new export controls that China has come out with as it relates to rare earth magnets. Those applications to get licenses to acquire those rare earth magnets require companies to disclose trade secrets, a lot of trade secret data that's really not necessary for the purpose of that application. So this is kind of something that permeates all of the business ecosystem in China. Anytime you have a product, you have to get it approved. There's this mandate to disclose trade secrets, and we view that as one of the top ways that China forces the transfer of technology. And then finally, I think enforcing IP, it's important to remember, that it's not just about acquiring rights through registration of a trademark or a patent. Especially in China, you have to come into the market with the understanding that most likely you're going to have to enforce that right. And so it's important to develop these strategies for not just protecting the mark, but monitoring use of the mark, and being able to investigate potential problems and then enforcing those rights. And as I mentioned earlier with the counterfeiting area, it can be fairly tricky to enforce those rights in China. And so we often will work with companies that are facing issues. Maybe it's a case of local protectionism, and those are cases where we can provide advocacy and draw attention to those issues with the courts and also through our official correspondence to the different agencies as diplomats in the host country to hopefully resolve some of those issues.
Thanks for that, Mike. And Rachel, so what are your 2 to 3 top issues in Western Europe?
So the Western Europe, it's a big region. And to be honest with you, the European Union is probably the area that I spend most of my time focused on because there is a lot of legislation that's churning out in the region. Europe broadly, but the European Union specifically, has a very highly developed intellectual property regime. And very similar to the United States. And also the European Union wants to be a leader in a lot of areas, including innovation. And it's also a region that issues a lot of regulations. The European Union government and Brussels specifically, it's a town of regulators. So there are a lot of regulations there. And so maybe I'll just touch on sort of a broad area, which is the digital space. There have been a lot of pieces of legislation on regulating in the digital space, including enforcing on the internet to ensure or address counterfeit and pirated products online, advertisements for those. And so we have been engaging very actively with the European Union to ensure that a lot of this legislation doesn't adversely affect our businesses. Of course, in this space also is artificial intelligence. The European Union, as well as a number of other governments, want to be a leader in artificial intelligence. This has implications on intellectual property, probably mostly for copyright stakeholders, because artificial intelligence, as I think many of the audience members know, ingests a lot of data. And some of this data ingested is copyright protected. And so there's a very live discussion in the European Union, as well as elsewhere in the world, including the United States, how to deal with this relationship between copyright and artificial intelligence. So this is also something that we've been actively involved in. The European Union passed the first artificial intelligence law, which is called the AI Act. And they're in the process of implementing that, which has implications for copyright stakeholders. So we are trying our best to stay engaged in that conversation, because many of our stakeholders, of course, will be impacted, those who are doing business in the region.
Thank you, Rachel. Thanks for those details in Europe. And Cairo, for you, what are your 2 to 3 top issues in the Mercosur region?
Well, it's hard to focus on just 2 or 3. I think our remit is so wide. It's part of the fun of this job, is that every day you show up and you really don't know what issues you'll be presented with. So it's a lot of fun. Like Mike, I'm going to have to go with enforcement as where I spend a huge chunk of my time, which is appropriate because most of the enforcement issues we have are sourced from infringing goods coming from China. So they're entering the Mercosur region. Unfortunately, Latin America is kind of awash in counterfeit goods and digital piracy, so it's a lot of work to counter that. In Mercosur, you have Paraguay, which is a country that really is sort of a transnational transit hub for counterfeit goods into the region. And there's a lot of very large, notorious markets in my region that are really a source of that. So we do a lot of work on that side. The second may not sound as interesting, but it's super impactful to our users, and that is helping with the efficient administration and good working order of local patent and trademark offices. So we work with IPOs throughout the region. I'd say they're probably our principal interlocutors. We certainly work with government officials throughout the governments, but from a day-to-day technical perspective, I'm working most commonly with the IPOs in the region. And it's really important to our users that those offices are run really well, that you can access them, that the rules and procedures are very transparent, that the fees are not too outrageous, that the examination timelines are not too long. So we really do a lot of work, and that could be anything from doing technical exchanges with the folks here in PTO on admin, on financing, on budgeting, on examination procedures, things that can really help make these IPOs better for our users. So that's a big piece of it. And then finally, I'm going to have to go with patents. I can feel the heartbreak from some of my stakeholders that are interested in other pieces of IP. But really, in my region, there are particular areas of friction when it comes to patents. I can think of extremely restrictive patentability criteria in Argentina, a lack of certain WIPO treaties that would be most helpful if they were to be acceded to, and of course, some serious backlog issues in Argentina primarily, and also some challenges in Brazil. So really, patents tend to take up a lot of my time as well.
Thank you, Cairo. This has been a helpful kind of scene setter. Right now, I will invite questions from the audience. Please submit your questions to usptohour@uspto.gov, usptohour@uspto.gov. And meanwhile, while we're getting those questions, I'll ask the panelists some more. So let's get into some of the harder stuff of what you do. Mike, what are the persistent challenges you face as an attaché in China?
That's a great question, Debbie. I think perhaps one of the biggest challenges is just the unpredictability of the environment there, and particularly now with the geopolitical relationship and the tensions there, it also impacts us and what we can do. I think one of the important things that we do is engage with our counterparts in China, and we do that for a number of reasons. We want to find out what they're thinking, what they're planning to do, and share that information to our rights holders so they can be prepared in terms of how to protect and enforce their IP in China. We also have an opportunity through that process to share information with our counterparts on the problems that our companies are facing. I was recently in Nanjing, in Jiangsu province, working with our rights holders, and we held an IP roundtable. We had about 12 U.S. companies there. Jiangsu IP office was there, as well as the courts and some other IP agencies that wanted to listen to some of the problems that our companies face in that region. That Jiangsu is just right around Shanghai. It's a large concentration of U.S. companies in that region, and they are important to that region because they're a large tax base and they provide a lot of jobs and investment in that region. And I think in that case, the local authorities were interested in finding out what those problems were and helping where they could address those issues. But unfortunately, a lot of the programming that we do, and we do have many years of experience and also memoranda of understanding with certain intellectual property agencies in China to help in our engagement. And through those programs and MOUs, we're able to prepare work plans that include programming and other opportunities to engage and exchange information. And this year we had a number of programs that were planned earlier this year, including in the space of pharma IP protections and also trademarks, online enforcement, trade secret protection. But unfortunately, one of our employees, PTO employees, was detained in China, so we had to pull down a lot of that program. So that's obviously a challenge when you have things like that take place that throw a wrench into some of the programming and things that you do. I think also just generally in terms of the environment now in China, it's making it difficult to have our programs. It was a time 10 years ago when I was in Shanghai where a lot of the programs that we did, there was an open and frank discussion about the issues and what was going on. Now, if we're doing co-hosted or organized programs with the IP agencies in China, they no longer allow us to have panel discussions, and they want to pre-approve all of the remarks that are given if it's a public program, and no Q&A from the audience, and that's made it difficult really to have the dialogue and understanding about the issues that our companies are facing when you can't have that open and frank transparency in our discussion. And then just, I think, living in China, sometimes, you have to realize and understand, and there may be people out there that are considering applying for one of our IP attaché jobs. Beyond, you have to consider also family issues and beyond the work, what is life like in the country where you're working. There are, obviously living in China is not like living in Alexandria, and many of the comforts and the things that you do perhaps day to day are not available to you there. I mean, just most of the services that we rely on, your bank, your insurance, a lot of the restaurants and places that you visit, they're not going to be in China. Social media, any of the kind of online or internet things that you do, you're not available in China. There's streaming services. Sometimes we're able to get access to those through VPNs, but that's kind of hit or miss. So just day-to-day things that you maybe take for granted living in the United States, you need to consider when you're in another country like China.
Thanks, Mike. So we've heard about the geopolitical issues, the sheer volume of stakeholder cases that they're facing problems in China, and kind of the day-to-day living. I'm going to switch gears a little bit onto something a little bit more positive, though. So Rachel, what's the most rewarding aspect of your job then?
Thanks for that question, Debbie. So I think I will say probably two elements of my job that I really appreciate is, one, while I have an intellectual property background, I have primarily seen policymaking in the area of intellectual property here in the United States. In Europe, I get to see how they make policy. And I understand I learn how their government works. And so I, in a way, feel as though I'm in a classroom and learning about policymaking and everything about the government in another country. And so that I find really fulfilling. And secondly, I really appreciate the relationships that I've developed with my host government counterparts. I think the fact that I'm able to establish these relationships with my host government officials also helps me to be a better diplomat and represent the United States, because I think when you are able to talk to your counterpart in a friendly way, I think they are able to confide in you a little bit more. And I think you're able to achieve your objectives a little bit better and faster. So I really appreciate that. And I hope that some of my host government counterparts, I will be able to continue building on those relationships, because I think we all move through governments, and I think that's really helpful probably for their government as well as our government.
Right. Now, I find the relationship building to be part of the most interesting aspects of being an attaché. So Kyra, I'm interested. So what really attracted you to being an attaché? You indicated your long career, you're at State Department, you're at Commerce at one point. Why come over to PTO?
That's a great question, and I'm the newest attaché. I've been in the job for a year and change, so probably good. I'm closer to the process of applying. Just full disclosure, this is my dream job. So it was not hard to apply. I was very excited to apply. And it really comes from that background. So when I was in private practice, what I really loved, what I found meaningful, was helping clients. When I was at State, what I loved was diplomacy, on-the-ground diplomacy. I thought that was so much fun. And when I was at Commerce doing trade policy, it was policy work and navigating the interagency. And so when I kind of step back from that, you've got clients, diplomacy, policy, clients, diplomacy, policy. It's like the iPhone reveal, right? It's not three separate jobs, it's one job, it's the IP attaché. So it's a dream job. I've absolutely loved it. I also got exposed to you guys. When I was in Tunisia on one of my assignments with State, I actually ran into an attaché for the first time. It was Aisha. She was visiting Tunisia, engaging with the IPO office, talking to stakeholders. I was an econ reporting officer, and so I was setting up her meetings and working with her on what she was trying to accomplish. And I thought that is a cool job, so I kind of filed that away. And then when I was at Commerce, I received a lot of reports from the field from attachés, and I kind of followed what they were doing. There was this one attaché in Geneva at WTO, and she was working really hard on the TRIPS Council. It was you. So, I kind of saw up close the value of this program, not just to PTO and its stakeholders, but to the United States. So super excited to apply, thrilled that I got it, and a dream job. And can I just say, if anyone is interested in this job and they want to talk about it, I actually did reach out to attachés and talk to them about their experience. You can find my email address on the website. Please reach out. I would love to have a conversation, do a quick Teams chat, walk through any questions, issues, concerns you have, because it is a fun job and we're always looking for interesting candidates.
No, thank you for that, Cairo. And on the USPTO website, where you can find information about the attaché program, all of the attachés' bios are on the website. All of their contact information is there. So do encourage you to reach out, and reach out to me as well. So I do have a series of questions, but I do want to repeat the invitation to submit any questions to usptohour@uspto.gov. So while we're getting more questions, let's go through a lightning round, shall we? And I'll ask the same question for each of you. Actually, can you each share a success story as a result of your advocacy? And relatedly, how did you measure success in that situation? So it's a twofer. What was the success and how did you measure success? Mike, let's go with you first.
Great. Yeah, I think that maybe I'll answer the second part of that question first, because I think for me, the most rewarding part of what I do and what I view as successes is when I'm able to help a right holder, in a problem that they're facing in China, and see how happy that they are when we are able to bring that type of result. One I can bring up that's recent, and this involves, I mentioned earlier how we have a policy that we follow through commerce, but we have this policy on when we can advocate on behalf of a right holder. And advocacy involves, bringing attention to issues and problems to the authorities through our official diplomatic correspondence and communication channels, as well as potentially attending hearings if it's a court matter, for example. And so I'm just going to share one issue or a case that we recently had, and this involved a technology company, involved a technology, $2 billion a year technology. There was an infringer that stole trade secrets and was infringing this technology in China. This right holder had been using multiple fora to go after and try to enforce through the courts, also in the United States. And this defendant in this case filed an action to invalidate the patent of this right holder. And they lost on the lower court decision, but on the appeal, the defendant brought the defendant hired a consultant who was a member of the National Party Congress and also the chair of the IP Judicial Committee. And they hired this consultant to help them influence the judge, because he also happened to be in close ties with the judge as part of his job, and also I guess they had some personal relationship. So in this case, the company had examples of how there were some ex parte meetings taking place, and they came to us with this concern about this attempt to influence the judge in this case. And with the evidence that they provided us, we determined that that was important for us to advocate on their behalf. So we brought this to the attention of the Supreme People's Court. And then we also had some correspondence and asked for participation in terms of having the ability to go participate in the hearing, which we did. Before the hearing, though, because of the correspondence that we had in this case, the judge was replaced with another judge, and so the company the U.S. company felt like that because of our advocacy and bringing attention to this case and the influence peddling that was going on, that they had this result. And we attended the hearing just a couple of weeks ago, so we don't know the outcome of the case, but we're hopeful that it's a positive one.
Great. Rachel, same question for you. What was a success story and how did you measure success?
Sure. So one of the elements I touched on about the various responsibilities I have, and I will note that I'm not working independently. I, of course, have others in my office, colleagues, very good lawyers. Many of us, or I think almost all of us, have local attorneys that we work with, so we work as a team. And so one of the things that we do is organize programs to share best practices. And that is actually used as a vehicle for our stakeholders, in that, of course, it's helpful to share best practices to help improve the local regime. But one of, or at least a few of our companies were having trouble contacting certain country enforcement officials. They were seeing a growth of their counterfeit products in that country. Their products were highly sophisticated and technical, so it would have been difficult to identify the real products from the counterfeits. And so they wanted to meet with local customs officials in this country to explain what their products look like, how to identify their counterfeit products, and then also just to notify them when they're aware of counterfeit goods coming in. And they could not get anyone to return their phone calls or return their emails. So what we did was we used one of the programs. We asked the host government, would they be interested in a best practices sharing program? And they were interested. And of course, many governments, including those in my region, are delighted usually to organize a collaborative program with the United States. So we organized it. We invited the stakeholders who were having trouble contacting the local enforcement officials to come and show their products. And they used that opportunity to network. So they collected a lot of business cards. So now they had people that they could easily contact. So in terms of how I measured the success, we received thank you emails to say that they were delighted with the program. They now know who to go to when they have a problem. So
That's great to hear.
Yeah.
Thank you for that. And Cairo, same question for you. Success, and what did that look like?
Sure thing. So the largest notorious market in the Western Hemisphere is called La Salada. It's based in Buenos Aires. In my view, not an official U.S. position. It's a wretched hive of scum and villainy. So it's a little Star Wars reference for you. This year, we saw a wonderful prosecutor in Buenos Aires take on La Salada, shut it down, lots of arrests. She arrested some really bad guys, and those cases are ongoing. We actually searched through our files and discovered that she was a longtime alumna of many of our programs over the past 5 to 8 years. Programs on exactly what she's doing now, how to really make progress on enforcement. So we got to meet with her and ask, what do you need? Because a lot of what we do is identify and empower local IP champions. If you can get those local allies, they're way more effective than the USG showing up as the USG. So very exciting development. And what she shared was she could really use assistance from brand owners, because when you're doing these cases, you need brand owners to take custody of the seized merchandise, to confirm that it is indeed counterfeit, to testify, to offer testimony, and all sorts of other assistance, down to providing vehicles and storage facilities. So it's a little technical. She also wanted some best practices from the Department of Justice on how you do chain of evidence kind of stuff. And we work very closely with the Department of Justice's iChip out of Sao Paulo. This program is the Internet Computer Hacking and Intellectual Property Crimes folks. So they're specialized in this kind of work. And so really putting all these people together to get a successful prosecution. So for me, that was really meaningful. And as far as success, it's a bit early. If there are actual convictions and deterrent penalties, then I think we will definitely see that as a huge success.
Great, thank you. Thank you for those examples, because it really shows kind of the breadth by which we provide the services to U.S. stakeholders, whether it's business counseling, not specific IP legal business counseling, but business counseling nonetheless, to be that, that helpful aid for U.S. businesses, whether it's working with government officials and developing programs to help that U.S. stakeholder, and then the kind of the public-private partnerships that you're engaged in and working with USG, interagency, as well as U.S. industry as well. So that's super helpful. I think we will move on to some of the questions that we've received. I don't know if I have time for another lightning round question. So the first question that we've received is, it looks like it's for Mike. What is the current state of enforcement of claims for patent infringement and trademark infringement in China?
If you're going to be in China, you really need to consider, how are you going to enforce? I think it's typically just a matter of time when you're going to have to face that type of situation. One of the reasons why I think infringement is so rampant in China is that there's just very low damage awards typically, and so there's no deterrence. And that's why you have a lot of infringement. So, kind of what are you going to do in those circumstances? And it all depends also on kind of what are your resources. If you're a small company that doesn't have a lot of resources to spend on maybe litigation in civil court, are there opportunities? I know we have a lot of companies that are selling into China through the online platforms and, using the notice and takedown systems and other methods of maybe some self-help. Is something to consider. I think it's important, though, that you hire local counsel, engage local counsel to talk about the options, because there are different ways of enforcing in China. I mean, they are very parochial when it comes to IP protections. It's, I don't think they really believe that it's a private right. And so you do have administrative enforcement, and you have ex officio authority to go after infringers, and that can be helpful. I mean, you can use the administrative authorities, the State Administration for Market Regulation, to help you in your enforcement. That can be helpful in terms that it's less expensive. Typically, you do have to do a lot of the investigation up front, and you're not entitled to damage awards in that type of situation. So I think it's a matter of taking a look at what your options are. There are new things that are popping up all the time. I think that, recently, because of the tensions in the trade relationship as it relates to the United States in particular, when you're talking about jurisdictions in Beijing area and Shanghai, our rights holders are telling us that in their infringement cases, they're now taking much longer. And at the district court level, they're required to have approval at the high court level in each of the provinces in those two regions before they can take any actions. The judges can take any actions in those civil court procedures. So that's a difficulty. They're not finding they're really discriminating against them in those cases, other than it's taking much longer. So that's an issue that is current. One other issue I'll just raise that just has started recently too, that was brought up by a number of rights holders in some programming that we had in Suzhou recently, is that the Public Security Bureau, which is their law enforcement agency, has now stopped the practice of allowing a local PSB, say for example in Shanghai, taking a case and handling it nationwide. And now they've required that you have to engage law enforcement in each of the locations, and you have to start with the location where the infringer is registered to do business. That is causing a lot of problems for our rights holders, who find that the infringers are all over, and obviously the infringers are now taking advantage of that system by having their registration in one location, and the infringement is taking place in other locations. So there's things like that happening all the time as it relates to enforcement in China. So again, important, I think, to hire local counsel so that you understand how best to approach this. Thank you.
Great, thanks, Mike. And it looks like there's another China question yet again. Not surprised. Do you still recommend filing for patents in China based on the current environment? Does current data show the filing to China have declined?
Yeah, I think that it absolutely does. It's important, obviously, if you have a patent, you have technology that can be patented. If you don't have the registration in China, you're not going to be able to enforce that patent right in China. But you also, I think, can consider whether or not there are other ways to protect it. You really need to develop this basket full of protections. Consider what can you protect as a trade secret. Now, in China, having a right, as I mentioned before, doesn't necessarily protect you from infringement, right? You're going to, the only way, I think, perhaps the most powerful protection is a trade secret, to the extent you can keep it secret, but there's also issues there. I think some people point to the high invalidation rate too in certain technology spaces. For example, in the biopharmaceutical space, foreign patents don't fare very well. Over the last several years, more than 75% of foreign pharma patents have been invalidated in China. So that's a concern, something that we're trying to address at the policy level as well. ICT space is also, I think, could kind of fall into that category. But again, yes, if you have patented technology and you're going to be coming to China with that technology, I do recommend that you still patent that technology in China.
Great, thanks, Mike. The third question looks like it's probably for me, but welcome any help. How do I best set myself up to become an IP attaché later in my career? Great question. So first of all, having a law degree, that is the first step, super important. A lot of our attorneys, the selectees that we have for these positions, have about 15 to 20 years of international IP experience generally. So that question is appropriately phrased. It is more of a later in career choice. Another, important avenue, to the extent that there are opportunities in the Office of Policy and International Affairs, doing a detail, working in that office is super important. That is the office where we focus on the legal and policy international IP issues. We're organized by subject matter and by country. They work very closely with our attachés. Just a plug for OPIA in that question. Anything else you would add to that, guys?
I would say there's not one path. I think if you look, and you can go, Debbie said it earlier, go onto the website and look at the bios. That'll give you an idea of what it looks like. But you have attachés that come solely from the private sector, usually with some international focus, folks coming with government experience only, and then folks coming sort of with a mixture of the two. So you can't be too overly prescriptive. I've always been one to think it's difficult to plan ahead like that. Just do what interests you and kind of see where it all goes. There are many paths to this job.
Yeah, I think I was a little bit of an outlier because I was from the private sector coming into my job. And I think I didn't have the policy side with my experience, but I think it was a good fit for Shanghai. It might not have been a good fit for Beijing because we do a lot of policy work there. But with Shanghai, we work with a lot of companies, large concentration of companies there. So I think they looked at the skills I had there, and that was helpful. But if you're in the private practice of law, I think there are opportunities there as well.
Absolutely, great. The next question: what sort of local assistance do you have to help understand the host government's laws, local law firms, embassy employees? So Rachel touched on this when she referenced her team, and all of the attachés have local lawyers working in the embassies and consulates with them. These are lawyers, again, with 10 to 20 years of IP legal background in the country in which the attaché serves. So we have IP specialists that have that legal background. They also have IP assistants to help with a lot of the logistics, the program planning, kind of the meeting collaboration and coordination that the attachés do. So it's a full team. But because you guys are on the ground, did I leave anything out on that?
Maybe just to add, so a lot of U.S. businesses have a presence in Europe, as I think in many other parts of the world, and many of them have they're experts in the region. And so we regularly engage with stakeholders, and also some of the stakeholders are represented by consultants or lawyers. And so where we are not entirely clear about a particular law or legislation, we will engage with the U.S. business in the region or a law firm, because there are regular interactions through various conferences and different kind of gatherings. And so we've established relationships with a lot of the local lawyers and policy representatives, and we can pick their brain if we need any help. But and of course, as Debbie mentioned, a lot of our staff, the lawyers that we work with, they're also very knowledgeable.
Mm-hmm. Yeah, no, that's across the board in terms of business presence in these countries. Also in Geneva, Switzerland, they're very active multilaterally too, so they're a great resource for information. So the next question, I think I could start off with that one, is in what ways do you work with other USG agencies? So it's a big tent in the IP field, international IP policy and legal field. There are a number of agencies that have equities on the issue of intellectual property. And in fact, we have agreements with these agencies to help post our attachés overseas. So we work very closely with the U.S. Department of Commerce International Trade Administration. They administer a great number of our attachés overseas. We have agreements with USTR. We have an attaché posted at the U.S. mission to the WTO. And USTR is the lead agency on the WTO TRIPS agreement, which is an international IP agreement. So we work very closely with USTR. A lot of the trade agreements, the reciprocal trade agreements that we're in the middle of, day-to-day communications with them. State Department, we do, because our attachés are diplomats, we work logistically and substantively with State Departments. Also, a number of the programming that we do, we engage with a number of our enforcement agencies to conduct the technical discussions and events that we have in country. So that's customs, that's border, that's DOJ, internet, computer crimes, a lot of acronyms I could say, but we work with the full alphabet soup on that. Moving on to the next question, can a small company approach an IP attaché for advice, even if the company has not entered a foreign market yet? That is a great question. Actually, we prefer companies to come to us early and often before there's a problem. Happy to have those conversations with you to kind of give you the lay of the land of, you know, where the attaché is, what the issues are, something for you to consider as you think about what markets to enter and what intellectual property you may or may not have, and you know what the IP landscape looks like there. Anything else you would add?
I'll just mention one thing on that regard. We work closely with the Foreign Commercial Service, and they have U.S. Export Assistance Centers here in the U.S. A couple of years ago, for China, Foreign Commercial Service Center, they basically established this new procedure that if you're coming to China for the first time, that you have to engage with the U.S. IP attaché first and have that type of a planning session for your IP before you come to China. So I think it is, absolutely important that you do that beforehand when you come to China.
Great advice. Can IP attachés set up engagement between U.S. and foreign judges, and are such meetings productive? I will hand it to Mike, maybe for you to start off on that answer.
Absolutely, and we find that that's so important. We used to do this a lot 10 years ago. We started back up after the pandemic last year. We had a judicial exchange between altogether in 5 different cities in the United States. I think there were about 23 judges in the United States, and then we had a group of district court judges from the United States that came out to China. It was very important because we had an opportunity, and China's kind of moving towards less transparency in terms of publishing cases. So we had an opportunity to have those type of discussions. How we're dealing with the hot issues like AI, for example. Also comparing damage awards. I thought that was very important, that type of engagement to show the disparity in terms of damage awards and how they can, that's impeding deterrence in China. The judges, I think, were also very pleased with that engagement. Helped a lot of the sessions where we had, I think, one session that was open, public, less debate and engagement, as I mentioned before, in that setting, but the others were in closed door sessions between just the judges. And I thought that the communication and the dialogue was very open and frank, and I think it helped us kind of share our perspective and the importance of why we do it the way we do it.
Thanks for that. Thanks for that detail. Great. Well, I think an hour has gone by. So thank you so much, OCCO, for the opportunity for us to talk about the IP Attaché program. And I want to thank my panelists for their insight and a really great conversation. Thank you all three.
Thank you.